The insolvency professional are in fact now more accountable, making the process fairer and more transparent. The proactive role of judiciary, particularly NCLT and NCLAT, and even by Supreme Court, has changed the scenario of this landmark statute of India. The shift, it was earlier, we know that entire process was data driven, data centric. Now the first time in 2016, we shift. The shift is from debtor in possession to the creditor in possession. And this model has proved to be successful. For it is strengthening financial creditors' decision-making power. This has resulted in improved recoveries, reducing the burden of non-performing assets. Operational creditors too have seen more structured and systematic approach in claiming their dues. Initially, creditors have to face so many hurdles. Either they have to go to for recoveries to civil courts or DRAT, then BIFR, AIFR, but everything proved to be time consuming and there was no proper resolution of stress assets. The framework has also addressed major issues, including classification of home buyer as a financial creditors, which is achievement in itself. The constitutional validity of Section 29A has also been challenged. And critical role of Committee of Creditors is well explained in various judgments by the Supreme Court. The IBC has been significant success in resolution process. At present, I don't have correct data of how many cases are pending and how many being disposed of. What is a percentage of recovery as far as financial creditors are concerned, other secure creditors are concerned, and operational creditors are concerned. But if we take the figures of 2019, still it was remarkable. Even at that time, the recovery rate was more than 50% as far as financial creditor, so also as the operational creditors and other stakeholders. We know that IBC has been enacted by the Government of India to resolve dirty dozen cases identified by the Reserve Bank of India. They were major defaulters. They exemplifying IBC impact. 6 of these cases led to major takeovers through resolution plans. In 6 cases, resolution plan has been successfully implemented. And I'm fortunate enough because out of 6, I dealt with 3 cases of them. One is at Binani Cement while I was at Judicial Member Kolkata. Then Electrotham, it was also in Kolkata, and SR Steel, which partly I dealt with while I was a Judicial Member at Ahmedabad. Now, recent regulatory amendments are there, which has strengthened the framework of India Insolvency and Bankruptcy Court. The Insolvency and Bankruptcy has seen multiple amendments aimed to strengthening the resolution framework. As of December 2024, the code has undergone 6 major changes, major amendments, and over 100 regulatory changes introduced by Insolvency and Bankruptcy Board of India. These changes are to seek enhance the efficiency, protect creditors' right, and ensure smoother insolvency resolutions. And one of most significant update has been the Liquidation Process Amendment Regulation 2025. This amendment seeks to streamline the liquidation process by reducing unnecessary procedural delays and ensuring maximum value realization for the creditors. Liquidation is often seen as a last resort, but when inevitable, it must be conducted effectively to prevent loss of assets. The amendment introduces stricter compliances requirement for the liquidators and fixed timeline for the asset sales. ensuring the liquidation is completed within a prescribed period of time. Similarly, the voluntary liquidation process amendment regulation to 2025 have made it easier for the companies to exit markets effectively. Voluntary liquidation earlier was very cumbersome process. It was often used to take years to get through. There were procedural inefficiencies and delays in creditor approval. Now new regulations have introduced simplified approval mechanism, reducing the time taken to complete voluntary liquidation and allowing business to wind up without unnecessary legal complexities. Another critical change which I see in nowadays is in fact relating to all we people, that is grievance and complaint handling procedure amendment regulation 2025. One of the persistent challenge in insolvency framework has been lack of structured grievance redressal system, not against only professional, but even against the other stakeholders. The amendment enhances transparency by mandating faster resolution of complaints against we people, creditor, and even insolvency professional agencies. It enables a dedicated online platform for stakeholders, and it has been introduced recently. One more aspect I came across recently, which was not there when I was judicial member. It is Inspection and Investigation Amendment Regulation 2025. It is aimed to improve insight over insolvency professional and agencies. With the growing complexity of the insolvency cases, the role of resolution professional has become more critical than ever. However, but we do come across some malpractices, misconducts, but they are everywhere. What is necessary, as far as I am as far as my personal view and my personal experience as a judicial member on NCLT for 5 years is concerned, I found insolvency professionals are updated. Their knowledge is more apt than any legal counsel or any other stakeholder involved in that. Oftenly, I used to take help while making decisions, obviously across the bar. We cannot say that insolvency professionals are not protected. There is a proper protection provided in insolvency bankruptcy code, that whatever done in good faith, you cannot be prosecuted, you cannot be called in question, your actions cannot be called in question. And this protection, we have to, we should, insolvency professional should not shy away approaching the tribunals claiming that protection if there is any allegations, baseless allegations are made against you. Now the model bylaws of governing board of insolvency professional agencies amendment regulation has also come. It standardized the governance and structure across insolvency professional agencies. These regulations mandate uniform training program, stricter eligibility criteria for insolvency professional, and enhance ethical guidelines to ensure that only qualified and competent professionals handle insolvency cases. Another noteworthy amendment in the proposal is to expand the pre-packaged insolvency resolution process beyond MSME sector. Initially, it was only to limited sector. Now, PIRP has been proven to be effective mechanism. Even I'm again lacking to data how many cases under pre-pack insolvency are being, how many cases are being filed and pending and resolved during all these 2-3 years, because when I demitted my office, it was recently be introduced in 2022, 23, and there were very few cases. Further, IBC now mandates compulsory reporting of defaults by companies to the information utility. Now, there are a number of steps which has been taken by IBBI, even in a statute also by the government of India. But there are some of hurdles we are still facing. In fact, one of the shortcoming of insolvency and bankruptcy code is that operational creditors are kept out of mainstream, and they are more in numbers. In fact, they are backbone. But now in Swiss ribbon, the Supreme Court has cleared this air, holding that the operational creditor cannot be in a committee of creditors unless the debtor has only operated, corporate debtor has only operational creditors, and they have to form particular numbers and particular percentage of debt they must owe. So there are so many hurdles. Even number of judicial pronouncement has shaped the insolvency, which I have already spoken. Now, the role of adjudicating authority has also been redefined by the judicial pronouncement. The amendment introduces fast-track mechanism of cases with simpler structure, allowing quicker resolution and reducing burden of NCLT and NCLAT. To enhance speed of recovery resolution, new amendment also proposes technology integration, and that will come very soon. In case management, this includes AI-driven tracking system, real-time monitoring of insolvency cases, and automated compliance checks to ensure adherence to the timeline and regulation. These changes will improve more efficiency and transparency, reducing the likelihood of procedural latches and delays. Additionally, IBBA has now mandated resolution professionals present all resolution plans received to COC, irrespective of their compliance status. This change ensures that the COC has access to all available options before making final decision, thereby fostering more competitive and transparent resolution process. Further, the introduction of special framework for distress infrastructure project seeks to address insolvency cases in an infrastructure sector, where large scale of project often face unique financial and operational challenges. I have come across recently very unique case that one infrastructure project corporate approached me with some opinion, and he gave me simple, very unique example. He says that he was awarded the contract to lay road, 50-kilometer road at particular region in India. And obviously, once contract was awarded to him, he approached bank, he collected all logistic, he collected finance, everything. But the government did not give the land where to that road is to be laid. Unfortunately, he waited for 1 year, 2 years, then there was NPA, then again restructuring, then again this was going on. And after fifth year, he could get that. But by that time, his account became NPA. That bank has approached for insolvency resolution against his company. That company has been taken by someone during resolution process. But there was arbitration clause. He invoked the arbitration against the government. He received 2,000 crore rupees. But ultimately, that amount also went to the new management. And ultimately, the poor person has to. So this is somewhat. How we can come out of these things, I don't know. We have to find out some way, because he is requesting me to suggest something, some amendment, some representation to be made, and we are working on that. Let us see. Then, as you know, the operational creditors are also facing challenges. They hardly get minimal. Hardly. I have so many cases in my mind that there has been certainly injustices done with those operational creditors. because ultimately they went, their company, their corporates, their companies went in insolvency because they did not get anything out of this process. So this vicious circle has to be stopped somewhere. And we being professionals, we have to find out, we have to suggest something to the government uh, uh, on this behalf. As I have already spoken about that the judicial intervention, the number of rulings have come to explaining the scope of the working style of NCLT, the scope, jurisdiction and scope of National Company Law Tribunal, National Company Law Appellate Tribunal. Few judgments we can always keep in mind, that is Swiss Ribbon, which has upheld the constitutional validity of insolvency and bankruptcy code and various sections therein. Then SR Steel versus Satish Kumar Gupta, which has interpreted the scope of section 29A of insolvency and bankruptcy code, that the who has lost the company, there should not be backdoor entry for them to again take control of that company. That has been clarified. JFE infrastructure rulings had given a gateway to home buyers to enter as a financial creditor and control the entire process. Gujarat Urja Vikas Nigam Limited versus Amit Gupta has stated exact boundary between jurisdiction of civil court, jurisdiction of other tribunals, and jurisdiction of National Company Law Tribunal to decide very ticklish issue. Then Phoenix ARC Private Limited versus SPED Financial, you may be knowing this case. It is regarding related party transaction. ArcelorMittal, again speaking about section 29A. Next case, Pioneer Urban, again constitutional validity of section 7.5 has been upheld. So there are a number of, then Maharashtra Seamless Limited, where say that it is not required that resolution plan amount should be more than liquidation amount of liquidation value, or it must be near to fair value, etc. Then case of Kotak Mahindra Bank versus Balakrishnan, that again is about holding secure creditors' right. So there are a number of rulings which has come holding the shaping entire this process. There are a number of hurdles. One, we cannot deny that. And one more important hurdle is delay in resolution process, because it wastes the assets. There are a number of cases where successful resolution applicant did not get anything, though his plan has been approved. And when he went to Supreme Court to withdraw the plan, so Supreme Court rightly said that there is no provision to withdraw the plan, and he has to adhere to that what promise he has taken. It is because process delayed more than 5 years. Even after accepting his plan, approving his plan, the implementation could not be done for more than 5, 6, 7 years, and that is why the entire assets are depleted. That is why this happens. We oftenly see that there are shortage of NCLT members. At 63 is a strength, approved strength in by the government of India, but hardly 50 to 45 to 50 members always we found working. There is lack of infrastructure, there is a lack of trained staff and whatnot. One more thing I have to speak about, that lack of specialization in a members appointed on the bench. One can understand judicial member having judicial background, having legal background, but expert member should be proper. I don't know what is the logic behind that. Only the person from the officer from that revenue service is to be brought. That should be changed. That entire approach of appointing members should be changed, and some persons who are actually working like you, insolvency professionals, should be brought as a member, because they know the procedure, they know how to deal with complexities, they know. So we have to consider all these things. There is also a problem of overlapping jurisdiction in between various tribunals and NCLT adjudicating authority. There is a filing problem, is there, e-filing problem. We are facing a lot of this thing. So number of challenges are there, but still we have to work in all these things. Since it is a keynote address, I cannot have more. When we go on discussing, we can take a part in that. But it has to be keynote address, and I gave some of the inputs to you. The insolvency and bankruptcy code has been transformative. We have to admit that. But continuous refinement is necessary to ensure its long-term effectiveness. Addressing challenges such as protected litigation, prolonged litigations, governance inefficiencies, and stakeholders inclusivity will strengthen its impact in corporate governance. By leveraging technology, increasing stakeholders' participation, and building more skilled workforce, we can ensure IBC remains a robust mechanism for corporate restructuring and economic reliance. Let us reaffirm our commitment to more balanced, efficient, and sustainable insolvency resolution framework that upholds corporate governance participation and contributes to India's economic growth. With this, I stop. Thank you very much. I thank all of you for giving me this opportunity to speak as a chief guest on this very vital subject. Thank you very much. Thank you.
Thank you so much, sir. On behalf of all participants, I would like to thank you once again to our chief guest and keynote speaker, Dr. Madan Gosavi, for this wonderful keynote address on present status of IBC and way forward. Truly appreciate that you have taken time out and shared your views, sir. I would now like to request our president, Dr. Ashish Makhija, sir, to please present a memento to our keynote speaker.
Yeah, I think okay, Dr. Gosavi, I think we have been very fortunate to hear from you, from your experiences. And I think it has been a great kind of a deliberation. You have stuck to the point, and the one point which is a takeaway, that the competence of the technical members is a very, very crucial aspect. And while you appreciated the efforts of the IPs, also their knowledge, you have also recommended that IPs should be appointed as NCLT members. I think this is something which has touched our chord also for all IP fraternity. So on behalf of IPNet, it is my privilege to extend my heartfelt gratitude to you for gracing today's webinar as our chief guest and sharing your valuable insights on the future of IBC. I think, sir, your deep understanding of the framework as a former NCLT judicial member has provided us invaluable perspectives on the present status of IBC and also the way forward. So, sir, we deeply appreciate your time, effort, and commitment. And now we request you to please accept this memento on our behalf, which is being shown on screen. This is a virtual one. We'll send you the physical and hard copy to you also. Thank you so
I
much.
receive.
Thank you. Thank you.
Now we'll come to the big announcement for the day. Before that, I'll just do screen share. Yes, friends. Before we begin today's session, we have an exciting news for all insolvency professionals. ICSI, which is the Institute of Insolvency Professionals, in association with IPNet, is hosting an exclusive roundtable discussion on streamlining processes under the code on the 12th of February 2025, focusing on the discussion paper issued by IBBI on 4th of February. For a long time, IPNet members have been calling for CPR's entitlements, and we have great news. Attending this session will earn you 1 CPR, making it an invaluable opportunity for all IPs. This critical discussion will be led and moderated by President IPNet, Dr. Ashish Makhija, sir, who's a well-known, renowned advocate and insolvency professional with deep expertise in insolvency law and practice. Registration is mandatory. With a nominal fee of just rupees 250 plus taxes, this is an opportunity you can't afford to miss. So all, please register right now. The registration link will be shared in the chat box shortly. Secure your spot and be part of the dialogue that is shaping the future of insolvency practice. Thank you for being the part of IPNet, a powerful community that empowers, informs, and connects IPs across India. Now let's move on to the next session. Sir, you'd like to say something, please?
Namrata, can you just scroll it a little bit above? You can show the ICSI logo also on the top.
Yes,
No,
sir.
on the top, yeah. So, friends, this is something which is very crucial for all of us. The discussion paper, which has been issued recently, I'll be leading discussion on that paper in association with ICSI, Institute of Insolvency Professionals. Well, IPNet has joined hands, and well, you will be entitled for one CPE hour. Okay, so friends, please register for this. I think Namrata will be sharing the registration link in the chat box very soon. Thank you.
Thank you, sir. With this wonderful beginning, we come to our first session of the day titled Recent Changes in CIP Regulations by our speaker, CA IP Jayesh Sangrajka. I request IP Vikas Jain to kindly introduce our first speaker of the day.
Bear with my sore throat a bit. CA Jayesh Sangrajka is a very well-known IP, and he's having more than 40 years of experience as a chartered accountant, as a company secretary. He's also, besides this, he's also LLB from Mumbai University, and he's an All India ranker, 15th rank in CA final. And he has handled many high-profile cases, especially in the field of home buyers, I would say. And apart from that, many other cases he has handled. He has been a co-founder of Incor Advisory Services Private Limited, which is a group company with a presence in multiple countries, I would say. He's also a part of a famous network that is Bedcatch, that is there. And he has been speaker at many forums, including our CA, CS, and many other forums. And he has been a keynote speaker, he has been guest of honor, he has been panelist at brainstorming sessions of IPs conducted by Triple IP of IBCI. He has been guest faculty to the universities and whatnot. In a nutshell, what I can say is that we will all be enriched with the great experience that he is having. So, with this brief introduction, I present before you our dear friend CA Jayesh Chandrajkaji. Thank you.
Thanks, Vikas bhai, Ashish bhai, Madan Gosavi Saab. It has been very what Madan Gosavi Saab has said, that India needs economic growth, and for that insolvency laws have to be simpler, and they play a big role to my mind in economic development of the country. Just why I am saying this, because the cases what I have resolved has added economic value of more than 50,000 crores. I can prove it, how it has been done. It has resulted into a revival of all the cases, big cases, like Aristo Developer Mulund case, which is adding 10,000 crore of sales revenue to the projects, to the sale that much houses are being constructed. Same with 10 BKC, and same with Ashiana, and same with recently I have resolved one case of 13,000 crores. So we play a big role as an RPs in economic growth of the country, and I always believe that we can play bigger role, subject to some support from honorable NCLT and IBBI. So in the process we may make some mistake, but as an RP we have to take bold decision. That's what I want to say. Now coming to the topic which has been given to me, I believe that the recent changes what are being prescribed practically have faced these challenges in all my resolution. Like first amendment is section 4E, handing over the possession. I would like to make it a bit of interactive also. Now, why this provision is required? So maybe because my experience has been, when we deal with large projects, there is a Indian Army. You can hear me, no, sir? Namrata, you can hear me properly?
Yes, sir.
Yes, Jayesh bhai, we can hear you.
Yeah. So like large cases like what I'm first case of mine was Aristo Developers. There were more than 500 home buyers, and to deal, and that was the initial days of IBC, which was this case was it started in February 2019 for me, and it is now 2025. So during those days, to explain to this 500 home buyers what is IBC, how what are their rights, how the process works, all that was really challenging for all of us. And we had an AR, so AR also played a critical part. But most of the time, as an RP, they wanted to understand, home buyers wanted to understand from RP team that what is the process, and we held many, many sort of groups we had to address, and there were multiple groups within that 500 people. So because there were different buildings, so there were multiple stakeholders. Some home buyers were allotted flat in 2004. They had bought in 2004-5, and some had bought in 2016-17. And so that 15 years gap also was there between home buyers, and the project nature of the project was also different. It was a large layout of 125,000 meters. So this provision regarding possession, because there was as such, this were all during the old before all the agreements were before 2016-2017. So the RERA also was not there. Only allotment letters were there. Registration also was not there, and there was a huge challenge to address the issues of the home buyers. So the question was of how do we register some documents, and whether we are empowered as an RP to register or not. That was a huge challenge. Similar thing happened in my recent case of Radius, which is called 10 BKC project, which Adani took over. There we fortunately it was subsequent. It was in year 2022, so we had some clarity, and we could we under the so there was some registration challenge, because in some document the stamp duty was paid. However, registration was not done. So there was no clarity whether I am empowered as an RP to register those documents. So then I approached the COC. I took their approval and got it registered. Now it has become a part of the law. Otherwise, it would have been. It is a it was really challenging to take that decision of registering the document. Otherwise, there was going to be huge loss of stamp duty in at least 4 or 5 cases. So that's the way we had to take that decision, and I took a decision, and we recorded it in COC minutes also. So what I advise is always record whatever out of the way decision you take, whether there in the COC minutes. That speaks. That is the main thing which we all have to consider while we take any decisions, which there is some gray area or some bold decision we have to take in the interest of the project. So then now the other amendment is regarding handing over the possession. Now what does the law say? After obtaining the approval of the committee with not less than 66% of the total votes, the resolution professional shall hand over the possession of the plot, apartment or building or any instruments agreed to be transferred under the real estate project and facilitate registration where the allottee has requested for the same has performed his part under the agreement. So here, what is the view of the house? Because what happens here is that in some large project, 1 or 2 buildings might have been completed, and there are home buyers, they are just waiting, and OC also might have come. However, the matter goes into CIRP, and some other home buyer categories of home buyers are there where the buildings are half completed. So in this situation, whether this particular provision allows you for registration or facilitate or hand over the possession. What I understand is that even if the flats are not constructed fully, OCs are not received. However, if we are able to register the document, because in some cases only allotment letters are there. I have seen in many cases only allotment letters are there and registration formality has not been completed. Whether we can take benefit of this and facilitate registration with the help of COC, with the approval of the COC, that is one thing which I feel that we can do it. But I leave it to our members here to have their opinion. But see, we have to take a decision in the benefit of the home buyers. with the permission of the COC members. Whether we can do it, this or not, that is one question which comes to my mind. Any view, Ashish Bhai or anybody on this, sir? So that's
Jayesh bhai, I have experienced such situation in the past, and we even wanted to complete the buildings also. However, COC knocked down the same in the past, saying that how can we do that when all the homeowners were ready? Even the capital was to be raised for the expenses from out of the balance spending from the flat owners. So it was very positive environment. However, the COC knocked it down somehow, and we couldn't do it. So that is what the situation was.
So let
So
me,
Udaira, I will come to that
Yes.
also. So
Let-
in my 10 BKC case, which has now the handover of the flats is happening today and tomorrow and day after tomorrow. So buildings have been completed. And during the CIP period, we had this interim funding of 700 crores. During the CIP period, we made the agreement between the which was approved by COC, between the RP and this for interim finance between Adani Group, and the interim funding of 700 crore was promised for completing the construction before passing of the order by Honorable NCLT for approval of the plan. So once their plan was approved in the same meeting, we passed this resolution for construction. Luckily, in that case, COC approved it and the construction started before the approval of the plan, which is now in the public record also. And it can be referred to radius estate matter was there. So I'm talking of the registration part, whether when in a particular situation like this particular case of radius or Aristo or Ashiana, these are all large cases, whether registration can be done when before even the OC is received. In some cases, if the registration has not been done, and as per RERA Act, more than 10% payment made, and you have to register the document, but the developers might not have registered. Whether with the approval of the COC we can register those documents or not, that is one thing which needs to be considered as per this provision of 4E. That is what is my question to the members here. And as per, to my mind, yes, it can be done. And with the COC's approval, RP can take that decision. Yes, Ashish bhai.
yeah, there is, let me explain this. Today, of course, we have got these kind of provisions by IBBI that this should be done. I'm talking about 2018 or 2019 when nothing was there. There was an OC which was received in a project. The IP approached us for our legal opinion that whether I can give a possession and also do the registration. We said whatever the amount which is due, say 10% or balance amount, you have to take that. And since the CCOCs are there, you can naturally give that possession, and it was given. In fact, somebody approached the NCLT principal bench also, and principal bench upheld that yes, the possession and the registration can be done. But having said that, the most important point is whether without the CCOC it should be given or not. If you ask me as a lawyer, it should not be given. Because tomorrow, if you give the possession and something happens to the building, because there is no completion, because some fire happens, because CCOC means all approvals have to come in place, fire approval, sewer approval, whatever approvals have to come. So if COC is cannot, you see, override the legal provisions which are given in say RERA provisions which are there. So unless and until you get the CCOC, I would suggest all IPs not to give possession, despite the fact that COC has also approved it. This will be too dangerous for the IPs in future. So that's my recommendation.
Ashish bhai, I agree with you. I was on the point of registration of the document before OC is available. So can RPs register the document? I am not talking about the possession, because possession naturally we cannot take that risk, because that is a statutory, we will be violating statutory local laws, and we cannot give possession without OC. I'm just talking, yeah. So registration of the document, whether that should be done if the COC agrees or not.
Even that should not be done, because we cannot, because as far as IPs are concerned, we have to follow other laws also. RERA says you need to have CCOC before you register and give possession. both the events are after the CCOC only. So if you give that possession, do the registration even before the CCOC is coming, I think we are going against RERA. This should technically not be done.
Sir, in Maharashtra, we normally when 10% above amount is paid, we can register the document, and OC and everything comes subsequently. Maybe in some other states, some other rules are there under
Let me pitch in. What Jayesh is trying to say is registration of agreement to sell.
Yes.
No, agreement to sell. See, agreement to sell is in any case registrable in all states now by paying some duty. Agreement to sell is like I'm willing to sell it. There is no problem. Agreement to sublease, agreement to lease. This is all right. But registration means sale deed. When we're talking about is sale deed. That cannot be done.
Sir, and other points,
Yeah.
sir, that agreed, sir. And now on the same point, so how the possession can be handed over is it has been defined here that the allotee has performed his part under the agreement.
Correct.
So
But
if
one
he has
doubt to
paid
one doubt
certain
to
amount,
Ashish sir. One doubt to Ashish sir. Undivided share of land can be registered, isn't it?
See, Mr. Bajaj, the point is everything is registrable. Let's understand one thing. Everything under the sun is registrable. Whether divided, whether undivided share in a property, but you have to follow the law. Registration Act Section 17 very clearly says that if it is an immovable property more than 100 rupees, whether divided, undivided, it doesn't make a distinction. It is registrable. If it is less than 100 rupees, well, you may not register it. But we know no property is less than 100 rupees nowadays. So the fact is whether it is undivided, whether it is divided. When you're talking about undivided, sir, we are not talking about the real estate project. Probably you're talking about, say, division in a family or some succession, something like that. But we are talking about real estate projects. So anyway, we don't want to go beyond a point. I think Jayeshji, it's your time. So you please go ahead.
yeah, sir. Sir, so that is one thing. And second thought which comes to my mind, because the allotee has performed his part under the agreement, but there are all these allottees are most probably funded by housing agencies, and they are also funded by banks and some or other sources, and some default in installments might be there. So we need to consider all those facts also before we hand over the possession. If there are some letters from those banks or SARFAESI or some act they might have initiated, all these questions would arise, but it will be case to case basis. We will have to deal it. Even there may be 138 matters which are there against the home buyers. They are being handed over the possession, but all those things what are the rights of those banks or institutions that we may have to think. That is my humble submission. Now coming to appointment, yeah.
Yeah,
Now,
I have one question.
yeah.
First is whether we treat home buyers as a secured or an unsecured creditors, because most of the time mortgage lenders say, "Okay, we will not share our mortgage rights in registration or during the registration or sale agreement." So nor they are ready to give the NOCs to the existing registered agreements. So the question of registration and registration of sale duty is very far-fetched. Even the existing registered documents, the lenders are not ready to give the NOC where they want to, where the possession has been taken by the home buyers without obtaining possession. They say, okay, we don't want to share our mortgage rights. We have a mortgage on the property, and during the course of CRP, we are not ready to we are not ready to share our mortgage rights, because home buyers, they treat as unsecured creditor, and they being a secured creditor, they have a higher right in the process. So can you clarify on this issue?
Sir, these issues are very much there in all. My view is from Aries to Radius and all other matters, whatever I worked on. There, I feel that I have always thought that they are all secured creditors because they have an agreement with the developer. With the knowledge of the bank, the lien is being created. And if we don't consider them as secured, the matter is lying in Supreme Court also, if I am not wrong. Mr. Ashish Bhai can clarify. However, I feel that they should be treated as a secured creditor, and under if the company goes into liquidation also, they are to be considered on par with secured secured creditors. Considering all the facts, I think more or less they will be treated as a secured creditors. This is a very big debate. However, let us move it to the second point. And this is my thinking is that they should always be treated on par with the
Because I have a majority of the real estate cases where claims have been uploaded on the website of IBC. None of the real estate cases it has been shown as secured creditors. Even the
So they are in a
big
separate
of the big
class.
cases in
They are
HDI, it is
shown
shown as
as a
unsecured.
separate class, and whether to show it as a separate class and secured, that is a question which we
because in the biggest of the biggest cases, maybe JP, maybe HDI, all the IPs have considered as unsecured.
Mr.
Sir,
Jadhav,
sir,
I think you are right. See, the point is, insofar as the company is concerned, the home buyers are treated as unsecured creditors. The question is that the lender has got a lien over a property. Now they are secured vis-a-vis the borrower or the home buyer. They are not secured vis-a-vis the company. So therefore, that cannot be treated as a secured creditor as far as the RPs are concerned. So this is the way it has been gone through. Of course, we will see the final outcome when the matter reaches the doorstep of the Supreme Court. So anyway, I think we can.
Yeah, sir. So now the other amendment is appointment of facilitators. Now, Ashish Bhai has himself handled one of my matter. That was Ashiana. In the matter of Aristo developers, where during that period, I had appointed, with the consent of COC members, we had, because there were large number of home buyers, so there were two class of association. So we allowed one or two people from each class to attend COC members, particularly the last 2-3 COC meetings where the plan was to be approved. And fortunately or unfortunately, I received a so-called notice for that, and Ashish Bhai and we handled it, wherein it was a question that any outside observer can be allowed to be attending such COC meetings or not. But for I had recorded in the COC minutes, and I had taken the COC's permission, and because of that, IBBI allowed, they did not pass any strictures on that. But this year, this particular clause, 16C, allows appointment of facilitators. There are some conditions, and that conditions is more than 1,000 home buyers should be there. In my view, there are very few cases where there will be more than 1,000 home buyers. But in any case, this situation is being taken care here, whereby if there are more than 1,000 home buyers, then we can, the facilitators can be appointed, and there can be maximum of 5 facilitators appointed, and their fees. Now that is very critical, and only RPs or IRPs, resolution professionals, can be appointed as facilitators, and their fees will be 1/5 of what is payable to AR. So with that type of fees, whether that is anybody is whether it is advisable for any RP or to take up this type of assignments, that is my humble thinking, that whether very few of us would be taking such type of assignments. However, what is the role of facilitators? It is being defined here. So as I said, and it is also for home buyers, and even maybe in some large cases, maybe some other class like debenture holders, or because I faced this issue in Ashiana, where there were 188 debenture holders, and they also wanted to be part of the COC, and they wanted to appoint observers. But with this type of whatever amendments are being made, we may be in position to appoint. Maybe somewhere there are fixed depositors, where there are large number of fixed deposits are there, debenture holders are there. That situation, I think, may allow facilitators to be appointed for, and their role is very limited. They have to interact mostly with AR, and their role is for communication purpose, and it is clearly defined under 16D clause, facilitating communication between the authorized representative and creditors of the subclass, attending the meetings of the committee as observers to facilitate the communication between creditors of the respective subclass, providing information and clarification to the creditors in the subclass, about the insolvency resolution process as per the advice of the authorized representative and any other tasks assigned by the committee to improve representation and communication. So it seems that this provision, with the experiences what we have seen over a period of last 6-7 years, this particular amendment has been made, whereby a observer or meaning a facilitator can be appointed. So there is an effective communication. Even we see that in large resolution CIP process, there may be 2, 3, 4 association also representing different class of home buyers or so there they may like that their own somebody from the committee or someone be appointed as a facilitator. No, they can appoint some facilitator to represent them from an as per this provision. Maybe that is the reason for this amendment, and I think it is a good thing. Only my reservation is on the fees part. Then the section 30C, which mentions on report on the status of the development rights and permissions of the real estate projects. Now, this is also with whatever I have resolved more than 10 cases, a value of more than 25,000 crores, more than maybe slum dwellers and including slum dwellers and home buyers, more than 20,000 slum dwellers. And every case in Mumbai, because I have been practicing in Mumbai, so and one case in Gurgaon has happened, which was Ashiana. Every case there is an issue regarding the land title. Who is the owner of the land and who is the developer? So if it is directly freehold land, then no issue. There is a CD owns the land and the process is simpler. But suppose CD has only the development rights. Like in my radius 10 BKC case, the land was owned by a society. Then there was a joint development agreement, and then there was another joint development agreement. In that situation, what are the rights of this joint development, the landowner is always a critical issue. In most of our cases, we are treating the landowner and we are not as outside the COC. We don't even admit their claims, and that is the reason there is always a friction that what are the rights of this this landowner and who has given a joint development right or development right. So this challenges I have faced in 4-5 cases, and in certain cases the projects are on slums. In Mumbai, most of the 30-40% is of Mumbai is slums, and many cases of slum projects are admitted into CIRP. I have been handling 4-5 matters. There all issue is the land ownership rights. There the SRA authorities are there. So lands are owned by BMC or the land is owned by government, state government or central government. Some lands the ownership is with MADA. In some region like Navi Mumbai, it is MIDC. In NCR, it is owned by Noida authorities. And all these challenges are there. To address that challenge, to at least to bring that landowners into the CIRP process somehow, RP has been given a responsibility here to to prepare a report detailing the status of the development rights and also the permission required for development of such projects. So this is first responsibility which RP has been given, and to submit the report, whatever this report is prepared, to the committee, so creditors committee for their comments. Now I understand that any project which is funded by COC, they should be aware of all of this. That there is a development agreement, there is a joint development agreement, and they fund and create mortgage basis that. So to submit, maybe some of the people, some of the committee members may not be aware of this, like home buyers or maybe unsecured creditors. But yes, we have to submit this report to the committee for its comment. And after that, within 60 days of the initiation of CIRP, this has to be submitted to AA. So this is supposed to be done by RP with whatever experience we have. first thing we should understand that we need to hire a proper legal team who understands the legality of all such type of agreement. Because what I have seen the challenge is that sometimes the project is stuck for long time, and there are development agreements which are, they what we call is step-in rights are there in the development agreement. So they invoke that. They cancel the development agreement also. All these challenges are there in such type of projects, and we have to take a proper opinion before we submit a report to COC as well as AA. And this needs to be part of the IM also. That also we have. In any case, we were doing this because unless you do all of this, no CRP can be resolved. Now, but however, now there is an explicit provision for making this details and submitting the report to AA, and there is now explicit provision. As an RP, we have to do this in any situation. That is, then we have done it in whatever cases I have handled. We have recorded in the minutes also, and during the process of submission, approval of the resolution plan, when we file our petitions also to Honorable NCLT for approval, all these facts regarding the land ownership is always mentioned. So this is what is regarding the disclosure of the development rights and permission of real estate projects. Now, every state has a peculiar way of doing, land transactions. Like South India, there is, undivided right concept. In Mumbai type of area, if there is a society redevelopment, then there is a different type of land documents are there. Then there are different type of authorities are there, like MADA authorities are there, MIDC is there, and NCR, we know what is the situation. So all this needs to be considered, and by employing a local expert in land laws. That is what is the crux of this particular provision. So now, as regards, there is a provision now. MSN, yeah, please.
Regarding this other statutory authorities, this SRA authorities, they don't recognize IBC as a because High Court, even Supreme Court in Truly Creative, I think, has given a decision. The SRA has a superior right over IBC. Whether it will change because of these amendments,
so
I don't exactly remember in Truly Creative.
We have certain cases where NCLT has upheld that moratorium under Section 14 is applicable to SRA authorities, and that has been handled by Mr. Rajendra Ganatra in matter of sunshine. And in my cases also, the minute we take over, if there was no 13-2 we call invocation by SRA authorities, then we immediately send letters to SRA authorities that we are there is a moratorium applicable to this particular cases. But I think that even in MADA, this has been upheld. There are case laws which says that MADA also cannot revoke any permission for development if there is an during the moratorium period. So I feel that there are sufficient case laws on this which protects from SRA or MADA authorities. However, the challenge is that what you are saying, it was a different type of case, because I know about that background, because I have met the promoters also. There, the High Court also was involved, and because the slum dwellers were not being paid their rent for a very long period of time, and that's the reason that the invocation of that 13-2 also can be invoked. That was the decision, and which is being again RP. It depends on the RP whether he wants to challenge this further or not. I think I have not followed it further, but this has happened 6-7 months back. So truly, developers, I am aware of it, and that's the way. But I feel there is a protection of moratorium as far as SRA authorities are concerned. However, the challenge is that after approval of the plan, because there is substantial delay. In one of my case, Anudan, there has been substantial delay for approval of the plan. Now, the slum dwellers do not understand IBC. So they go to the various authorities. They again, after approval of the plan, they approach SRA authorities. They approach revoked SRA authorities revoked the plan after 32 approval, after the approval of the plan by Honorable NCLT. Now the matter has gone to High Court as well as NCLT. How this can be done? Because there was a dispute regarding the amount of rent to be paid to the slum dwellers for this extended period of CIRP and all that. So that's the reason SRA authorities conveniently, Thana authorities have revoked that and invoked 13.2. But they have done after the resolution plan is approved. Now that is another thing which has happened, and one or two more cases similar things have happened, because local authorities have to be have to be told or have to be explained the provision of IBC, and that's the only way. Otherwise, SRA will not be protected after even getting the resolution plan approved by NCLT, particularly in SRA matters, slum redevelopment matters. So that is where we are. And as regards other changes, these are all major changes what we have discussed so far. So there is an MSME provision also, which where in some cases even applicant, the promoters have applied for MSME after COC's approval, subsequent to CIRP process also, and COC approved, and we had to, the MSME application was made because they were qualified for it. And so they also participate in the CIP process. Now the voting is going on, so let us see what is the outcome. Some other plan has also come and promoter has also given. So MSME provision is there, which may be beneficial for existing promoters. That is where the amendment has come in. Form G also has to mention this MSME status. Now it has been made mandatory. And I am also asked to disclose this. So that is what, as far as MSME is concerned. So anything I'm missing or anything, Namrata, faster? So the view, this key impact of these amendments, as we know that IBBI has been very proactive. They have been interacting with all of us RPs also. Wherever real estate matters are there, I am also invited. And we have shared our experiences. But particularly now certain amendments regarding interim funding and all that, maybe it will come. And this is like, most of the time IBBI feels that somehow home buyers have to be protected, and there has to be monitoring mechanism also once the plan is approved. So that also has come in this particular amendment, that RP or some other RP can be part of the monitoring committee. And quarterly reporting has been made mandatory. Like in my matters, virtually all matters, in spite of first matter of Aristo also, they had made provision. Honorable NCLT themselves made a provision for monitoring committee. And here now statutorily it has come in the law that there will be a monitoring committee. The fees definition is also there. And but I feel that if there is a long process of 5 years, 6 years, or 10 years to monitor the project, because sometimes the life of the project may be 5 to 10 years also. So this is a very long process whereby every quarterly reports will have to be filed, and it has to be submitted to IBBI as well as EA. So this is what is my view on all of the amendments, whatever has happened. Thanks for this opportunity, Ashish bhai, Uday bhai, and thanks Namrata for sharing the screen. Thank you very much. I hope I have covered everything.
Yes, sir. Thank you so much. I guess Rashmi Jadhav, I hope she's online. She was wanting to ask something.
So Rashmi Jadhav incidentally is my partner only. So
okay.
no issues. So we have been dealing, and she has also dealt in some very good matters of liquidation in real estate. And there are Manish Jaju is also, we have worked together. Uday bhai, so we know. So many here RPs are there known to us. Thanks a lot. So Rashmi, anything specific? Yeah. I think she is not there.
Yes.
Can I ask a question? I'm Partho Sen.
Yeah, sir.
Yes, sir.
Now, actually, in a project which I'm handling, the promoter has given possession to the allottees, and then it will stay there. But there is no OC, no CC, and also registration is not done most of the cases. My point is, what is the status of this possession? I mean, if the CRP gone into liquidation, whether this home buyer, they have to vacate their flat or no? I mean, as per that Supreme Court order, they can retain it as their property. Because there is a written possession letter from the promoter side.
So I don't know, Mr. Sen, whether this project is in Mumbai or Maharashtra.
No, in Kolkata.
It is in Kolkata. So here the point is that RERA became applicable, I think, recently in Calcutta. And but however, if it was in Maharashtra or in Calcutta anywhere, once the possession has been given in Maharashtra, what we do, builder developers before OC, they give possession 6-7 months before, just to make furniture, etc. And in some cases where the home buyers themselves come to know that developer is in problem and building is 90% or 95% complete, so they don't want to take risks and they just shift into the houses, and and they try to, with whatever facilities are available, they stay there. But if this matter goes into CIRP, then naturally RP's role, we don't have that authority to remove them and dispossess them. We cannot admit they will make a claim also, because OC is not there, but they are occupying, so they will submit their claim, and naturally we will have to accept that claim because OC is not there, if that is the situation. And we will have to possession, we cannot dispossess under any law, normal law also we cannot dispossess anybody. They can be dispossessed only through the process of law. That is my view as far as your question is concerned.
And also, and another thing is that my part is as the heir for the allottees. So when RP admitted their claim, RP didn't accept their value for the base value for the flat. They said, no, you are taking the position, so I am not accepting that.
So that view is
that means that they are really owner of the flat now. If RP refused to accept that base value of the flat.
So whatever amount they have paid, I think that it should be admitted as a claim, and there should be a note that they have been handed over the possession. That's the only thing, because money has to be protected, whatever is being paid. If for some reason, if the matter goes into liquidation, at least that claim amount should be on the record, and that is what is the correct position according to me.
Right. So
according to me, in the liquidation, there is no possession. Once you have a possession, you don't have to file a claim. There's some regulation 43, something like that. I don't remember exactly.
So these are very few and far cases, and a law will develop on this. I feel home buyers will be protected under any situation, whether liquidation or other than CIP process, so they will be protected. You cannot dispossess a person if they are already having the problem.
Absolutely. So another point is that in that particular case, I mean, the secured creditors have the huge voting share. Voting percentage, they are more than 66%, and this home buyer has a very negligible, voting share. So I mean,
so that happens.
How to ensure
we will discuss this offline. You can call me anytime. But yeah, so there are these cases, very many cases. There are home buyers are having 5-10% only voting power. Secured creditors, because of interest, penal interest, etc. And so many charges, their claims are always high. So we have to deal it case to case basis, but we have to reason with COC. Our role is as a to solve the issues. So we have to reason with the COC and explain to them also, and they will understand. According to me, the COC also understands all this. Anyway, my last thought on this is that we are referring to the CIRP process of a corporate debtor only. And we need to think that how partnerships and proprietary concerns are brought into this framework, because there are huge number of projects which are even RERA statistics, more than 10,000 projects are stuck, and most of them would be proprietor or a partnership concern. So I feel that the time has come that this all entities also should be covered under CIRP process, under resolution process. Thanks a lot.
Thank you so much, sir. Thank you so much for this wonderful session and for sharing your enriched knowledge with us. I would request Dr. Ashish sir to please present the memento.
Yeah,
Ashish.
no, so I'm so sorry. Okay, Jayesh bhai, I think you have been wonderful. Thank you for your time and sharing knowledge with all of us. So on behalf of IPNet family, please accept our certificate of appreciation. Online, virtually, we'll send the hard copy to you.
Sir, thank you, Ashish bhai. You are doing a great thing through IPNet, and I am sure that we will all there are 90 participants there. There were more than 105, I think, at one point of time, and I'm really happy that so many people are associated with IPNet. Thanks a lot.
Thank you so much.
Thank you so much, sir. Thank you so much. We now come to our second session for the day, titled Key Points in Preparation of Resolution Plan, by our speaker, Mr. Praveen Nawamdar, sir. I would now request Sumit Datta to kindly introduce our speaker. Mr. Sumit? I guess he was just online.
To introduce Navandarji, who is having his team of 30 employees and a founder of Saksham Insolvency Resolution LLP. He is DISA qualified, did a valuations in 2010 from ICI, again did a registered value course latest in 2018, insolvency professional 2017, Master of Business Finance, which is a long year course, and he has been he has taken numerous sessions on IBC, more than 100 across the region in WIRC and other cities like Rajasthan, Jaipur, Raipur, Vadodara. Being a core founder convener of Ghatkopar CA Study Circle, ex-committee member in WIRC, has been an ex-committee member in Bombay Chartered Accountant Society, current member of IBC committee in WIRC, and has been a special invitee to ICA Central Council IBC committee, past president of RIPA, and I had the privilege of knowing him personally, and he's a man of golden heart. I had a fortune of meeting him in Mumbai in Train the Trainer training organized by World Bank, and he invited me, first time I met him there, and he invited me to his office. And then I liked one book him. I said, sir, this is a very good book. And he said, Sumit, go and take that. I never find somebody who you say something and go and take that. And it was very kind and gesture. So it's a privilege knowing him, known as one of the best professionals in making resolution plans across the globe. So with this, without much ado, I request C. Praveen Nawandar sir to please address all of us on your topic.
Thanks, Sumit, for the golden words. Actually, I don't remember that I had given the books to you, but that was, I think, long back. I think 2018 or 19. I don't remember, but good. We had met at Bombay, and I really liked him, and that was a simple thing. Thanks, Udayraj, thanks, Namrata, and thanks, Ashish sir. Ashish sir, from the day one, we have been the follower of Ashish sir, and whatever we know, at least major part of it through the Ashish sir only. And it is an opportunity to deal with the members, and when the Ashish sir is there, what we should speak, that is the question. Chalo, but out of experience we will speak something. You have given me the presentation, right, Namrata?
Yes, sir, you can share the screen.
One minute.
Yes, sir, it is shared. We can see that.
Yes, you can see that. Thanks. See, ultimately, resolution plan is the end thing where we come out of the IBC. There are few thoughts on this. First is always we should, while doing anything in IBC, we should always remember the preamble, the insolvency resolution for the resolution of the company. Ultimately, preamble doesn't talk of liquidation, but that is the final outcome of the resolution process if the resolution is not there. And in between, we had a time of liquidation as a going concern, but now in yesterday's paper, the IBBA is trying to curtail that. I don't know whether it is advisable or not advisable, but IBBI is not very happy with the liquidation as a going concern. But according to me, it is if there is a revival hope, one should try it. An attempt should be made for going into liquidation as a going concern. In ArcelorMittal and every other cases, number of cases, it is held that the resolution should be the uh, best. One should put in all the efforts for the resolution. And I have seen at times the number of times the NCLT gives the extension also if the resolution is happening. So we must not forget that CD consists of several employees and workmen whose daily bread is dependent on the outcome of the CRP. If there is a resolution applicant who can continue to run the corporate data as a going concern, every effort should be made and try to see that resolution is possible. Even our Gosavi sir referred to Maharashtra seamless case where the resolution plan was little less than the liquidation value, but there also it was held that there is no condition that the resolution plan should be always exceed the liquidation value. It could be seen that one of the principal objective is providing revival of the CD and make it a going concern. Every attempt has to be made to revive the concern and make it as a going concern, liquidation being the last resort. This is an entire chart of what happened. There is a default application to NCLT orders CRP. If it is revival, then resolution is the revival process or liquidation. Resolution applicant, a person who individually or jointly submits a plan to a RP pursuant to invitation made under section 25 2H, the eligibility criteria. Resolution plan proposed by resolution applicant for insolvency resolution of a CD as a going concern. Now, initially there was no provision for the amalgamation and merger, but later on in 69, it was clarified that the resolution plan may include a provision for restructuring of corporate debt, including by way of merger, amalgamation and demerger. So this has really helped a lot because at times we see that a company is acquired by a strategic investor and they want to merge it along with its own company. Or at times if there are multiple units in the plan, say CD, then one unit one may demerge and other unit may later on be sold, or that all possibility is there. Now IBB has also come out with the discussion paper on that. What are the basics of the resolution plan? It first of all it assures more or less clean slate. Then there is a high competition among the resolution applicants, and whosoever wins the who is SRA, successful resolution, get the company. For other PRAs who have incurred heavy cost, it becomes a sunk cost. Second thing, it has become very time consuming process, statutory process and very time consuming. At times at Bombay NCLT we see that it takes more than a year to approve a resolution plan, and that is creating a lot of issues because the value is depleting. Any concern which is already closed down, where if the assets are not put to use, the technology and all other depletion starts at very high rate. And lack of information because promoters are not cooperating or the information available is very minimum, and that is the resolution applicant has to deal with lack of information. Then what if we compare the amalgamation merger with resolution, then here under resolution there are no warranties, representation, conditions, covenants, indemnities that are customary in to MA transaction. Resolution professional only gives disclaimers. Normally what resolution professional says is as is, where is, what is basis, how is basis, without recourse basis and accordance with the IBC 2016. Make it a discussion oriented. If any point is there, we can discuss. See, IPNet is for more for a discussion. These are the few basics which points I have noted down. Other basic security performance guarantees needs to be given. There is a evaluation matrix, information memorandum, RFRP document, EOI, 29A checklist and eligibility criteria. These are the basics of the all basic things which are required for a resolution or IBC.
So a
Please
couple
say,
of questions on the last slide, just for
yes.
the discussion purpose. With disconnect of the evaluation matrix from who will be the highest bidder or who can be selected by the COC as the winner,
Yes.
and evaluation matrix score having been disconnected, is it no more relevant other than for academic purpose? That was one question we had.
Yes.
Another is 29A check is always a problem for the RPs. The COC may not want to fund independent 29A check. IP is required to undertake whether a particular plan is 29A compliant or not. The COC
Yes.
says certify that. And who would fund the cost in such cases? Because there is no guidance as to how it will be done in the code or in the regulation. Everybody is just putting responsibility on the IP to complete this.
Yes.
So how to address this particular issue? These are the two questions we come to the mind, sir.
Sir, evaluation matrix, you rightly said that now COC may look at it, may not look at it. It is just a COC may look at the only value, but evaluation matrix, even if the score is on the higher side, they may not approve the plan because all the plans are put up and it goes as per the voting. Same 29A, there is a heavy cost of 29A check, and COC is not ready to incur that cost or fund that cost. And more so if there is an international buyer, then the international connection, then the cost is further high, which we faced in one of the case. And now in eligibility criteria, the IBBI discussion paper says for the home buyers, the eligibility criteria can be relaxed.
What is the eligibility criteria in cases of ARCs and NBFCs?
That is a true. COC has let down the eligibility criteria in discussion with the RP. That is the only eligibility criteria for any plan, and that is plan specific. 25(2)(h).
But for ARC, the net worth is 1,000 crores. No,
100 crores.
no,
Now they have increased to 300 crores.
No, sir, that is their net worth. ARC want to participate as a resolution applicant in the CRP process. Their minimum net worth at least 1,000 crores. That is the basic criteria. That is
They
the
cannot do
basic
business.
criteria.
They cannot do business as such.
Correct, but they have provided, RBI is also provided, if their net worth is
But
1,000
there
crores
should
and
be a
above.
there should be a co-applicant for them to be a part of the resolution process. Because ARC themselves cannot do a business, they can be a financial partner in the process.
Yes. I think
With
one of the
the
first case was the Edelweiss, which plan was rejected of, I don't recollect the name, but Edelweiss, that Bombay tribunal rejected the plan because it was just buying the plan and giving it. Edelweiss was the ARC who had submitted.
That was in the matter of Bharati Shipyard, sir.
Bharati Shipyard, yes. Our insured council member was the RP. Dinal Shah was the RP, I think.
that plan was rejected by them.
Yeah, that plan was rejected by Bombay tribunal.
So there's a question from Brijesh Singh in the
Yes.
chat box.
1 minute.
Yes, sir. Sir, I have a query as to whether there can be any resolution plan for a CD which has no running business as on the CRP date. No plant and machineries as on date of submission of plan. No workers left. However, there are few assets which include few residential properties located in different parts of the country. In my view, there cannot be any resolution plan in this case. In fact, it is case of disposal of assets of the CD. Hence, submission of resolution plan in such case with the object of acquiring residential properties cannot be considered a valid resolution plan. Hope I am right in this understanding as far as resolution plan is concerned.
In case they have some proprietary right, yeah, like most of the traders they have. I had one case where we were advisor. There was a good amount of trading business was carried out, and what the company had did was that out of the earnings of that business, lot of properties were purchased, but that doesn't mean that there was no business. If there is any sort of business which has been closed down, if it is a goodwill, if it is a name, trade name in the market, then the resolution plan can be there. Na? But if there is nothing, then one may take a decision under the COC. See, RP is just a face of it. He can put it before the COC and let COC take a call that we take the company to liquidation. And ultimately, if we try to do it in the liquidation, the value may further deplete because anybody buying in liquidation may further discount the price. So value maximization may be affected practically. But there is no as such law written down anywhere or regulation written down that there should be no resolution. It is a decision by the COC. That is my input. But members or Makhija sir or others can have their input.
That is fine, sir. We will keep on discussing these issues. Now we can proceed now.
No, for the resolution of the listed company, takeover code is not applicable. Change of promoter group can be carried out. Approval of resolution plan need to be informed within 1 day to the stock exchange SEBI. Delisting is delisting of shares without going through process, and public shareholding can be brought down to 5%, subsequently to be increased. These are all very good benefits which are given by under IBC for a listed company, and we see that even if the company which has no business, no this all types of companies, they have a good value. Even if there is no business or no employees or no asset, they like empty box also generate value because of the listing benefit. At times it is seen that, and at times we see a lot of promoters keep asking, "कोई listed company हो तो बताना." We are trying one delisted company to be taken over under the liquidation as a going concern and then again relisting. That is also going on. This all sorts of activities are going on. But if the liquidation as a going concern is stopped, then the this listing, whatever benefit is there, that will also vanish. Any question or any point or any?
So there is one more question
Yes.
from Mr. Ravi Kumar. If a resolution plan is approved and shared with COC, but voting has not been taken place, then fresh information is received, can the information memorandum be amended?
It depends upon the cruciality of the information, and information memorandum is the information memorandum up till the plan is approved. Whatever information you get, that needs to be circulated to both the RA and COC members. And then you will have to have one more COC meeting for putting up again the plan for approval. The members of the resolution applicant will be given the opportunity to amend the plan. See, this being a commercial law, there is no well-defined, there is no strict process for everything. It is ultimately what Jay Shankaraj can take. The RP has to take the bold decision. What is the information, how far it will affect, whether it will really affect the value of the plan or whether it is very crucial. And sometimes what happens, after the plan approved also there is a lot of, what you can say, misfortune happening. I had one of the case where after the plan was approved by the COC and before the NCLT approval, there was a big storm and well, the entire rooftop was damaged. So this whole situation one has to face. It all depends upon what is the cruciality of the information and what it is and how it is.
Thank you, sir.
Now, regarding SEBI, I have a question that there is a mandatory rule of 20% shareholding by the promoters. So how is it taken care of in case of resolution plan? And what are the relaxations available? Is there any circular or guidance from SEBI on that? about minimum 20% shareholding by promoters. Post resolution, how and when it should be achieved, or how are there any case laws that are known to us?
No, no, I am not aware of. If anybody is aware of, or I will have to look into it.
We will park that question aside. If anybody
This is Divyesh Desai. What I understand is that the SEBI requires 25% public shareholding, and generally in cases where in resolution plan you end up having 100% stake. So SEBI permits you a time of 3 years, SEBI or the exchanges, to reduce your shareholding to 75%. This is what I think in Ruchi Soya also they did, and in some of the other matters also, this is how it is done. So either you keep some public shareholding or you take time for reducing the public shareholding, increasing the public shareholding.
That was initially. Now what they have made it at minimum 5% at the beginning only you have to give. Earlier
Yeah,
it
so
was not.
that is how you structure. You keep some stake for the public shareholders,
Now 5% is
or
compulsory.
you give it to the bank when to the financial creditors, and balance. Then you take time for diluting it to 25%.
आवाज बंद करा मला इथे बोलायचं आवाज जाईल.
Now they have reduced the time limit also. Earlier the time limit was higher. Now they have reduced the time limit also.
I am talking to one merchant banker in one of my matter where he indicated to me 3 years, but yeah, that needs to be changed. But what I'm trying to say is that of course this policies of period and all will keep on changing. But whatever time is permitted, maybe one can increase the public shareholding over that period of time.
See, I'm Nitin Panchal. Can I speak?
Yes, sir. Yes, sir.
Yeah, in one of my case, before this 5% cap came, in the resolution plan, it was we have reduced the shareholding below 5%. And the plan was approved by NCLT. And subsequently, SEBI took an objection to that. BSE, we received a letter from BSE, but we told him that as the timelines, the resolution plan was compliant with the existing guidelines prevailing at the passing of the resolution plan. So we told him that since these guidelines have changed to minimum 5%, so they gave us a 6 months window, and within that 6 months window, the new SRA complied to the guidelines. Initially, they told us that you put up this plan for approval again, but we told them that the IBC does not permit the already approved plan for putting up for voting again. So SEBI agreed to that, and they gave us a 6 months time. And within that 6 months time, we complied with that 5% norm, and it sailed through smoothly during the implementation.
Good, good. Thanks for the information. Any other point, or we proceed? Now, the basic of what happens is when we are appointed as an IRP, our duty is defined under section 18, where we under subsection F, it is a take control and custody, where the explanation says that for the purpose of this section, the asset does not include the following, namely A, then B, assets of Indian or foreign subsidiary of a corporate debtor. So any assets of the corporate debtor subsidiary company is not been to be taken control and custody of. Now at a typical case, large case, where the holding company was just an paper company and all the assets were in the subsidiary company only. And in the holding company also there was no loan, but because the holding company had given letter of credit, all loan devolved and they came on the holding company, and because of that the holding company was under the IBC, and the real issue was I am a company with a claim, large claim, huge claim, and no asset, and I had no alternative but to take the subsidiary, because all assets were not only in the subsidiary but they were abroad also. 100% assets abroad, 100% liability sitting on the balance sheet. So this, if any representation is to be made, this also should be, because at times 100% subsidiary asset is there, then it is nothing but an holding company extended arm. I will request IPNet, if any representation is made, this should be point to be pointed out. Any point on this? I was handling a case, large case, where almost all nationalized banks were there, and asset is abroad, only the liability sitting on our balance sheet. Now, another typical issue which I faced was the right of first refusal. In our joint venture agreement abroad, there was a right of first refusal, where any time I want to sell my stake in that company, the foreign partner, my joint venture partner, will have a first right, whatever the price I sell. Now, when I discovered the price, I invited resolution plan, I invited everything happened. Then ultimately the joint venture, I had to offer to joint venture partner who is sitting abroad in a foreign company. He said, I have a right and I will exercise that right. So what option should I? Should I go with and that was the statutory obligation. That was the obligation arising out of the agreement, which was done 10 years back. So I had to approve that. The COC approved that. If the party has the first right of refusal, that has to be accepted. They will be substituted as a resolution applicant without being submitting any resolution plan. They just submitted the right acceptance letter and they become a resolution applicant. And that was upheld by NCLAT also. NCLT, the other party challenged it. Ultimately, it is upheld by the NCLAT and it is all done. But these are very important things. The international party filed tooth and nail for that. In these 6 months, the litigation was going on. ROFR cannot be accepted, this cannot be done, they were not a resolution applicant. How can RP entertain somebody who is not a resolution applicant? But, and even 238 was challenged, saying that the IBC override. The only point we said was IBC override if there is asset is in India. If there is a foreign asset where joint venture company is there is no override. Any question on this? Because this was a typical situation which I faced. I thought of sharing it.
So Praveen bhai, sorry.
Yes, Judge bhai, yes.
So any contractual, my view is that any contractual right can it be overridden by resolution plan? So
my thinking is a contractual right laid down by the contract which was prior to commencement of IBC will have a upper end compared to other.
Yeah, so same thing is happening in joint development agreement rights and other thing also. So
Yes.
most of the lawyers are advising that don't submit claim if you are a landowner and don't submit the claim, your contractual rights are protected. So that is one of the reason I'm asking you. And any contract with a JV partner or a partnership or a or a subsidiary, I think all those we need to consider, particularly when a foreign investor is there or foreign assets are there.
In our contract, there was clear for right of first refusal. If I am selling my asset, I will have to give my first right to the joint JV partner. If he is selling his stake in the company, he will have to give that same offer to me.
But that is governed by the shareholder agreements.
Shareholder agreement, yes.
Yeah, correct. Anyway, thanks, sir.
And
But, sir, but when in data room, this must have been disclosed, right?
Yes, clearly disclosed. It is clearly
So then
disclosed.
it should not be a point of dispute, because if it is disclosed
then
that
if
if it is disclosed that there is some party which has a ROFR, I mean, then nobody can
but
challenge.
everywhere it was disclosed and everywhere it was challenged and everything was challenged. But see, when there is a large asset, everybody wants to have it and they don't mind spending
Of
that
course.
amount on the litigation. And
Yeah,
lawyers
agreed.
also advise them that do it and with due respect. And lawyers also said, okay, if you want, we will fight it.
Agreed, but I'm talking more from IP's protection. IP is safeguarded. Once it is
IP
disclosed, once it
one
is
is it
disclosed,
disclosed, and second thing, COC has approved that.
yeah, so then
If
I
the
think at
100%
least,
COC is approved, more than 99% COC is approved,
yeah.
and it is
Okay,
flowing from the right.
that's what. So once it is disclosed, then I think everybody has to honor that.
Vikram Kumar has a query.
Praveen bhai, I just had a point that I'm audible, right?
Yes, sir. Yes, sir.
Yeah, under section 20, I'm just reading, section 20, subclause 2, subclause B, which says that the IRP shall have the authority to enter into contract on behalf of the corporate debtor or to amend or modify the contract. So, do you believe that this provision can be utilized, or used by the RP or the IRP, in the interest of the CD?
See, correct, but then why he should now? First of all, in my case, what was that? The asset was lying in the subsidiary company. The contract was executed 10 years back. And eh, and what was there was no advantage. Whatever the amount X resolution applicant is X is giving, the same amount my partner is giving. So why I should?
So, you have a point, but I'm asking, suppose there is a situation.
Why I should in that situation? Suppose you
No,
are
I
giving
agree.
me X amount and Mr. Y is also giving me the same amount. I'm just substituting the resolution applicant.
I got your point.
Can I come in here?
Praveen, I got your
Yes,
point.
sir.
No, Vikram ji, actually, I think we have to read it with a slightly pinch of salt.
Yes, sir.
What 22B says is that RP can enter into contract or amend contracts. This is not unilateral amendment. Amendment means if both the parties agree, naturally he has got right to amend or modify it. It is not a unilateral power because you read the first sentence, to enter into a contract. Can he enter into a contract on his own? Naturally there has to be a second party. So therefore, amendment, modification, or entering into a contract have to be read in a same passage, which means both the parties should agree, then he can modify it. It's not unilateral, he can't do that.
So any contract, sir, which was existing prior to CIRP,
Correct.
if he wants to modify, then it has to be agreed by both the parties.
Absolutely, sir. Absolutely. In
Right.
fact, see, we should also look at Supreme Court judgment where Tatas were rendering kind of facilitation services. So IP say RP said, sorry, I will not honor this. Supreme Court said, sorry, you can't ignore this. So therefore, though that agreement was held to be valid. Okay.
Right, sir. Thank you. Thank you, sir.
Praveen bhai.
Yes, sir.
So there is one more query in the chat box, Mr. Subhash Sharma. Is he there online, Mr. Subhash Sharma? They have a query on the
With
amendment.
continuation, what Raviji said and your guidance that information memorandum can be amended and shared with the PRA till the plan is approved. What will it be required to be shared as addendum or changes? I think addendum or you simply convey it through email to all the prospective resolution applicant and COC member, or you word it as an addendum. Information should reach the PRA. If we find that most of the time the information is shared in the data room and almost on daily basis the data room is information is added, and we just write to the PRA that there is an addition into the data room. That's all.
Thank you, sir. So one more question has come in from Mr. Hari Prasad. Resolution plan is submitted by an individual whose name is appearing in the final list of PRAs. The proposal in the plan is 5% contribution from the individual and 95% from another company. The individual and the company independently meet the eligibility criteria and are also 29A compliant. Will there be any objection to the resolution plan?
Actually, what conditions you have laid down? Because nowadays we find in the RFRP there is a condition laid down that that in the way consortium every member should have minimum 20 or something, or there should be proportionate contribution also, or eligibility criteria of at least 1% should be met. All this maneuverability of the eligibility criteria is done. One will have to look at the case by case basis and what is ultimately tried to achieve.
Thank you, sir.
Sir, Udayraj or sir, if any other point on that.
Sir, we will certainly come back to these points after we are through your presentation. I think we can proceed now.
Then there is a submission of resolution plan, that is a normal section under 29 compliance. Then section 30, which is there, we provide for payment of the debt of the operational creditor in such manner as may be specified. That is normal provision is there. 30 continued. And then again here, what the burning point is that the section 34, the COC approves the resolution plan by a vote of not less than 66% of the voting share of the FC after considering its feasibility and viability. Now, in one of the recent case, the COC was asking feasibility and viability. I said it is your lookout, not RP's lookout. Nowhere the RP should say the plan is feasible or viable. Because tomorrow if the plan fails for any reason whatsoever, RP, they will catch hold of the RP. So it is purely a COC's decision about feasibility and viability. My whatever suggestion to the all the members is nowhere, even if they provoke the COC members provoke to the RP, nowhere he should comment on feasibility and viability of the given plan. Second thing, what is yes?
If I am allowed, in fact, a similar question was put up to me in one of the COCs before principal bench in Delhi, and we had recorded in details as to how the feasibility and viability would be conducted by the COC and not by the RP. Multiple questions were put up. One of the apparently dissenting member went to NCLT and said that RP is not doing his duty of feasibility and viability. There was a discussion and arguments going on for more than 4 hours since morning till lunchtime in the NCLT, and we were able to prove that we have discussed all this in the COC and the duty is cast upon the COC members to do this, and bench agreed with this and even said that this is a frivolous litigation and we would, why should we not impose a cost of 1 crore rupees on the litigating COC member. So, but we supported and said that let the better sense prevail, and the matter was decided against that particular lender. And finally, that lender voted in favor of the plan. But this feasibility and viability is a very critical subject in preparation of plan, and IP should be very clear and it should promote that COC should record its feasibility viability, and even in the resolution that is passed for approval of the plan, these words can be incorporated. That is our understanding.
Yeah. This was the main point of communication. Though all RPs are aware of it, but I thought at time we in the plan, whatever plan approve हो रहा है तो कर देते. No, we should never. And the COC member particularly try to ask question, pointed question, according to you what is it, and then they try to record it in the COC meeting. The major second point is the manner of distribution of the proposed, which may take into account the order of priority among the creditors laid down in the section 53(1), including the priority and value of the security interest of the secured creditors. Now at times we find that though the secured creditors, everybody are secured creditors, but some may have a higher security value and some may have a lower security value. So this point, see that security interest point is only stated here in the code, nowhere else I found it. Under section 53 also there is no distinction between the secured creditor, difference of secured creditors. Somebody may have a building which is, they may have a loan of 10 crore and building worth 50 crore, and other people may have a loan of 50 crore and have an asset of 10 crore. So all are treated as a par or not par. This question always arises in all the COC meeting at the distribution stage. So any point on this? Most of the cases we find this. The security, when there are different lenders, working capital lenders, they have security but nothing is left. There is a term loan lender, for them asset is less. And while distributing the plan, everybody is given on pari passu. So that those members who are aware, they try to litigate. They want to differentiate. Any point, Udayraj sir? or Makhija sir?
Praveen bhai, if you permit me, I had a query, sir.
Query or answer? So
No,
Vikram sir,
I
you are here to
want,
give answer, not to query, raise the query.
sir, I had a point to make on this feasibility and viability. So do you think that the RP has the responsibility to intimate the COC that you have to examine the feasibility and viability, and how the feasibility and viability has been examined by the COC should be at least recorded in the minutes so that, subsequently there is no litigation around the subject?
But they will not give the report now. What we will say, we give them the point that COC to, after studying the feasibility and viability, should put the plan in the approval over they take the decision. But they will
No,
not
my
give
point
their
is, could it be minutized in the minutes?
they will minutize in that minting that this we have stated them. But then again their study will be internal document that they will not bring to the table.
So, I have a slightly different view. I think that, how the feasibility and viability was examined by the COC should be recorded in the minutes is something, which I have this view.
We just record after they take a decision after studying the feasibility and viability and doing that. But they don't bring their report or why it is considered as viable and why they voted for the plan on the. They don't revert with their internal report. What the members think.
Maybe Sir
If I
Ashish
may,
sir can throw some light on this.
if I may, what normally we practice is when we are working as an IRP or RP, we encourage the resolution applicants to obtain a techno-economic viability study done, encourage them, we cannot bind them, and provide it to the COC, which sometimes helps the COC to arrive at a conclusion. Because according to me, we are enablers and we are not there to point out mistakes of parties. So when we cannot even bind the COC that you do feasibility, viability in whatever manner you want to do. If we are able to provide some kind of assessment done by the RAs also, that can be provided to the COC so that they can also do independent study. Now there is a further question whether this feasibility viability should be a joint exercise by the COC or each member will do it on its own. According to me, it will be an independent exercise by everyone.
Okay.
However, it is left to the COC to do it, but the duty of the RP is to record it in the resolution that they are approving or not approving the plan after taking into consideration the feasibility and viability.
Okay, if I can come in, let me, take up the first question by Mr. Vikram. I think that's a very important question. Now, the first is, as far as the feasibility and viability is concerned, it is already provided in regulations. I believe it is Regulation 38, Sub-Regulation 3, probably clause number B or C, I don't remember. It says that the plan must itself plan must itself say that it is feasible and viable. Number one, it is a duty of the SRA to do that. Second, now if you look at regulation number 39, and that is sub-regulation 3, there is a mandatory requirement on the part of the committee to record its deliberation on feasibility and viability of each resolution plan. So therefore, there is a recording of the deliberation which is mandatory as per the regulation itself. So I think the committee has to evaluate, because we already have an evaluation matrix. So evaluation matrix is also one of the aspects. Then of course, feasibility and viability, in the sense that whether it will revive the company or not, whether we have distributing in a fair manner or not. I think those things are to be recorded, and they are now mandatory for it to be done. So to answer Mr. Udayraj's question, well, it has to be, typically everyone will come with their own individual feasibility and viability study, because they are all bankers. And in the Swiss ribbon case, Supreme Court says that they have got wherewithal, they have got infrastructure to have reviewed this. So once they have done that in their own offices, then of course it's a joint exercise on the table. They have to deliberate. It is as per the regulation itself. So common deliberation is also required by all CLC members.
But sir, in most of the cases, if there are only one major member, say 70%, 80%, and other are unsecure, then they just vote for the plan and that's the end of it. What recording the RP will do?
Sir, can I say?
They go by generally, say if SBI is a partner, ICICI Bank will not say anything. We know that. So that apart, that's a separate thing. But
Ashish sir, what is your view on recording in the minutes, the deliberations?
I've already said here, I've already said that let's read regulation 39 sub-regulation 3. What does it say? It says the committee shall evaluate the resolution plans received under sub-regulation 2 as per evaluation matrix. Then second, record its deliberations on the feasibility and viability of each resolution plan. So joint recording is a must. That is what the regulation says.
And
So
sir, recording is in the minutes only?
absolutely, sir. Where it is going to be recorded? It is.
Sir, can I speak about this something? I have also done the same thing. I have recorded everyone's deliberation, stated this regulation only to all COC member, and one by one I have called upon every COC member, whether he is 10%, 20% or 30%, and recorded in front of each COC member whatever they have views regarding the plan. I think Makhija sir will agree to this.
Yeah, definitely. See, it's a question of process. If they are not coming out naturally, RP can simply say that, look, what is your view? Supposing they submit a view, record it. If they remain silent, you say the question was posed and they remain silent on this. That's the end of the story then.
Sorry, go ahead.
No, go ahead.
See, in one of my case, there were two set of lenders. One were having a major charge on the fixed assets, and the other were having a charge on the current asset. So we told them to hold a GLM and to decide about the sharing pattern, which was eventually done by them. And subsequently, one of the secured financial creditor voted in favor of the plan, and the plan was voted with 100% share. And after I filed the plan with NCLT for approval, that particular bank filed an IA stating that it was like voting under protest, and they filed an IA stating that we are happy with the resolution plan figure, but we are not happy with the distribution pattern. Eventually, that was restored up at both the levels. At NCLT also, they again knocked the door of NCLAT. There also that IA was disposed of.
So you are right when you say that, you see, they have voted, then they must vote with the open eyes. Now they can't come back and say, oh, we voted, but we are not happy with this. I think this deliberation or this argument will definitely be rejected by NCLT and should be rejected by the
Yes. There you cannot have a voting under protest.
Correct. Oh, no, nothing like that. Okay, I think we had a good discussion. So, Praveen bhai, if you can just complete this.
I won't actually, it is a long time.
Doesn't
Resolution plan is the heart of the subject, and if you give me one more opportunity after say 15 or 20 days, I will be happy to complete it.
Okay, all right, sir. So anyway, wherever you want to stop, I think we can have more.
I think we will have to stop. I have to attend some social function also, and time is also over. Because resolution plan is the heart of the total IBC, and it cannot be completed and I don't want to rush through. We would like to have input from all the members and so it become a real study.
So the lesson for Uday Raj is that we should have one speaker for resolution plan in one seminar.
Yes. So I have one question. My name is Subhas.
Yeah.
See, in one of the home buyers case, the allotee bought the first and then it is subsequently registered to the another person, another buyer. So how it will be treated in this? Allotee will get the property, or the subsequent registered person will get the property?
No, sorry, we have not got it, sir. There was a home buyer. The flat was allotted to one person, right?
Yes.
And then
subsequently registered to another person.
Registered means he
registry is done. Registry is done.
No, he sold it, or it was registered by the promoters.
By the promoter.
Therefore, one flat was sold to two people.
Yes, please.
So there you see, the point is, here you can't, as an RP, you cannot sort out that dispute. So please refer them to NCLT, let them sort it out. Because registration and allotment, of course, registration has more value than allotment, no doubt about it, right? Even in law, the registration is considered to be more evident, but there can be a case of fraud also. So if the person to whom another allotment has been made is not happy with the registration, let him go to NCLT. So I think as an RP, we cannot decide on these aspects.
So NCLT can decide on this that or they have to approach the court.
Well, they have to refer it to NCLT. If NCLT feels they can't do it, it's a civil matter. They will say, sorry, we can't do it. Fight it in the civil court.
Okay.
Okay.
Thank you so much.
Thanks.
Thank you, Praveen
Makija
sir.
sir, thanks madam, and thanks Udera sir, Namrata madam, and all other dignitaries for giving me an opportunity to start the topic here.
Thank you so much for today.
There is no dignitary here. We are all fellow IPs out here.
Yes. Yes.
We belong to the same fraternity. Okay.
I request Ashish sir, please present the memento to Praveen sir.
Absolutely. It is my absolute honor and a delight. Praveen bhai, please accept this on our behalf of IPNet family. I think you have taken time out of your busy schedule. You are about to go to some family function. Will not hold you. So please accept, on our behalf. Thank you so much.
Thanks everybody.
So much, Praveen sir, for today. This was really wonderful seminar. Looking forward for more learnings and knowledge sharing webinars. Our next webinar is next week on 15th of February at 4 p.m. Topic will be announced soon. With this, we would come to vote of thanks, but yet again, I would like to mention about the special announcement. ICSI Institute of Insolvency Professionals in association with IPNet is hosting an exclusively roundtable discussion on streamlining processes under the code on 12th of Feb. This is already the link has been shared in the chat box. It will be reshared on the WhatsApp group as well. We have been trying to get entitlements on CPE, and this will earn you 1 CPE hour. It is being led and moderated by President of IPNet, Dr. Ashish Makija, a renowned advocate and insolvency professional. Registrations are open and it is mandatory. It's only 250 rupees plus taxes. So register now and please join in and have this knowledge sharing seminar. With this, we come to the vote of thanks.
Yeah, Namrata, just one thing. Friends, I think IBBI has issued a 12-page, 13-page discussion paper, which is huge. I think it is going to have huge ramifications. I don't know whether we'll be able to complete it in 2 hours because 2 hours have been given to us, but we'll try to do our best. Seek your comments. I'll just make a presentation that what this proposal is all about, and then I will speak less. I think the members will have to contribute. So please join on that 12th of February. It's going to have a very, very interesting discussion. And of course, you will earn CPE hours also.
Hopefully by that time we have an income tax new bill, so we can incorporate it.
We will definitely. I think, you see, I have already spoken to one income tax expert, a very great expert, because IPs also do face a lot of income tax issues and even RAs also face. So I think we'll have a great discussion on purely on income tax on one day.
That will be great. So I've already registered. Looking forward to see you all over there. And I'm thankful to IPNet for giving me this opportunity to deliver the vote of thanks. First and foremost, I would like to extend my heartfelt thanks to our chief guest and keynote speaker, Dr. Madan Gosavi, for enriching us with the keynote address. To our wonderful speakers for the day, Jay sir and Praveen sir, I would like to take a moment to truly appreciate the insights you have both shared with us today. You have enriched this discussion in ways that will undoubtedly influence our work. The depth and knowledge and wisdom you brought to this session is invaluable, and thank you so much to both of you for your dedication. Thank you to our very special president, Mr. Ashish Makija, sir. Your unwavering commitment and vision for IPNet are what makes this platform so special. As you shared your thoughts today, I felt reassured that we are on the right track under your able guidance. Thank you for being that guiding force and inspiring us to aim high. And of course, a big thank you to Transition, our technical support team. You may often work behind the scenes, but you are the backbone of all our events. Finally, to each and every one of you present today, you made this day truly special. Your enthusiasm and engagement has elevated today's discussion. Thank you once again for all being present. Thank you. Thank you so much.
And I think thanks to Mr. Udayraj Patwardhan, I think it was a fantastic topics, very well organized, and of course to Namrata. I think the stalwart who is carrying on the torch, you see, and of course, Mr. Rajesh Shah and all other persons who contributed. Thank you so much for taking, sparing your valuable time. Thank you.
Looking forward to 15. Thank you.